So good evening to everybody. Welcome to the European Institute of the Mediterranean. I know that you are now at the master's program at the University of Barcelona, so I hope that you are enjoying your time in Barcelona. How many of you are from Barcelona, so that your family lives in Barcelona? No, I mean the students of the master. So the majority of you come from where? Italy, 1. France, 3. Northern Africa, any country? No, so you're all European in principle. But I see some people from where? I'm from Taiwan. From Taiwan. Wow, that's far away. Okay, and the others, where do you come from? You, for example. From Argentina. Okay, okay, okay. So, thank you for being with us this evening. It's a special occasion. I will explain you what it is about, why it is special. We are very happy to cooperate, in this case, with the University of Barcelona and Professor Laura Huici and all the Department of International Affairs and International Law. It's a prestigious department at a prestigious university, so I congratulate you. You've made a good choice, as you will see. And I hope this will be a fruitful program for you. Aula Mediterrània is a program that we have established from the European Institute of the Mediterranean with the different departments in the different universities in the area of Barcelona, who have a program, a graduate program on international affairs, and so that we cooperate with all these departments organizing this cycle of conferences all along the academic year, both semesters, and so that you may come almost every week for a session here, either organized by your professors at your department or by the other universities, which compose a program that you can find very easily. It is therefore this is the 9th year that we are organizing this cycle of conferences, and it is 10 different graduate programs from the different universities in the area of Barcelona. University of Barcelona, where you are, the Autonomous University of Barcelona, Ramon Llull, and well, all others. Without my lenses, I cannot read it because it's the eBay. Well, you don't know still so far, but Blanquerna, Abat Oliva, Ramon Llull, etc. So it's the main universities in the area of Barcelona. Furthermore, we organize once a year a big seminar, which is more addressed to researchers and professors, with different parallel sessions organized by the different universities, and we're inviting over at each parallel session with 4 speakers coming from anywhere in Europe or in the Mediterranean area, which is open to you as well, for graduate students. And then pay attention, because we organize an international jury to attribute a prize for the master's final work that you will have to prepare probably within your master program. And we have a final a prize plus some finalists, and hope some of you will win the prize. Okay, so this is the first reason why this is an important evening for us. The second one is because we will have an extremely interesting conference by Professor Stefania Negri from the University degli Studi di Salerno, as you know, on crime against the environment, which is, I would say, a too much interesting affair these days. And the third reason is because we are today at the opening of this cycle. So it's the first of these sessions, and then we have Mr. Miguel Royo, who is the Secretary of External Action of European Affairs in the Catalan government. So I am extremely pleased because it is not only that, he has been very recently nominated, so I know that he's made the effort to come, and one of the first public appearances in the academic area. Furthermore, he is as well somebody from the academic field. He has been studying at the London School of Economics and Political Science. He has been studying, I think it was University of Manchester?
Birmingham.
Birmingham, oh, okay. And he will explain us what he has to explain to us from his point of view and from the point of view of the Catalan government. So really very much, thank you very much for making the effort to be with us this evening. And all students, professors, and myself were really happy to have you with us and really eager to know what you want to say us. So you have the floor. Thank you.
No, thank you so much. Muchas gracias, Ambassador Florenza and everyone here. I know you're not here to listen to me, so I'll be extremely brief, but I do want to, as you were saying before, you say where everyone was coming from, and I'm from here, so I'm very happy to see that you've chosen Catalonia to study, and you've chosen the universities in Barcelona. So from the Catalan government, we're always excited to have new people come and learn about the reality and the cultural day-to-day of our life here. So thank you so much for choosing Barcelona to study. And I also want to thank Ambassador Florenza and the IEMed for inviting me here today, not only to listen to a very interesting conference afterwards, but also for its excellent work in bringing the reality of the Mediterranean and the policies around the Mediterranean to the Catalan society and to the Catalan government. And he said I was nominated, I think 2 weeks ago, was appointed to the role. I spent all day speaking about budgets, so I'm very happy to speak about real policies in Mediterranean and things that affect our day-to-day life in more of a, not so much thinking about numbers, but thinking about real policies that decision makers have to take into account when they go and they look at their day-to-day work. So thank you, IEMed, for this work that you do, and also for bringing together different universities and different research centers that are central to the future as Mediterranean citizens, that focus on issues that, as I was saying before, are essential for our day-to-day as citizens here. And the conference cycle that we're inaugurating today is an opportunity to reflect on some of these issues. Today it's environment. I think throughout the next few weeks, we were talking about it before, consumption, science diplomacy, migration, press freedom, human rights. I think I'm missing still quite a few, but those are some of the issues that we talk about on our daily basis in our government and in our work, and it's good to have also the research centers that focus on these issues to give us policy inputs later on so that we can implement them. And so we are privileged that IEMed is accompanying us to work together with these universities and these research centers and do their part in promoting the work and research that have the Mediterranean at its core. Because the Mediterranean, at least as you said before, I've studied abroad and in the UK, and it's an area that is often overlooked, divided into sections. We have, Southern Europe, Northern Africa, the Middle East. But for those of us that have lived here and have more of a personal affiliation with this land, it's a whole. It's one area that binds us all. I don't want to quote Lord of the Rings, but we do feel it and we see it as a whole. So it's excellent the work that you do, and we really thank you. And not only is it the day-to-day reality of what happens in the Mediterranean that influences political opinions here in Catalonia, but also at a European level. We see them in other countries that don't know much about the reality of the Mediterranean. They take important immigration policies after they see what's happening in the Mediterranean. They take important agricultural policies. So it's important that we transcend, that the research transcends this idea of a divided Mediterranean and gives a complete and complex look into the reality of where we are. Because if we want to take the right policies, we need decision makers, need in-depth analysis and knowledge to understand the many cultures, the many visions, the many realities of one single space that we live here. So we need more research, and we need institutions like yours, and we need the work that you do, and hopefully that you will do in the future that focuses also in the Mediterranean in order to build a true Mediterranean community that is able to speak with many voices, but with one true objective of creating a better future for a common land, despite its many differences. And it's not only IEMed, it's not only university, it's not only you. Now is when I talk about my work. The Catalan government is also doing its best to work in this objective, we have a specific strategy, which is the 2030 Mediterranean strategy, that looks at, we're trying to make sure that it has specific goals and measurable goals so that we advance towards a better future for the Mediterranean, especially in the area of research and innovation. We're promoting and supporting research centers and this kind of initiatives for years to come. We're fostering exchanges of students between Catalan and Mediterranean universities, and also with a clear objective. We want to make sure that Catalonia remains the hub of Mediterranean research. And we talk a lot about how Barcelona is the capital of the Mediterranean, or at least one of the capitals, but we need to put those words into actions. And so that's something that we strive to do every day, and I'm sure that we will continue doing for days to come. But we need to be more ambitious. We know there's still work to do. We know, for example, that one of the main objectives that we have to achieve is increasing the exchange of students between Catalonia and Barcelona in the north of the Mediterranean, which is an all-time low. But if we want to build these personal relationships, these personal history that binds us all together, we need to promote this kind of exchange and make sure that this objective of building a common community is shared by institutions, universities, research center, academics, students, so everyone here in this cell, in this room. However, the value of the conference cycle that we are inaugurating today, I think is a good example of this, of everyone here together working on this same objective. IEMed have created this inter-university space in which knowledge sharing is promoted, and you will have us by your side as you continue growing this, and you will have us as students by your side if there's anything you need. And obviously, if you decide to stay in Catalonia anymore, we'd be very happy of you to be here and focus and find out more about the day-to-day of life here. Finally, let me just add, I hope you have a great success. We're here to listen to a very interesting conference, so I'm looking forward to coming down and listening. And I hope that the conclusions of today's conference and of the future conferences help us create new partnerships, help us, know new colleagues, help us, in conclusion, build a better future for the Mediterranean and for Catalonia. So thank you so much, and I look forward to listening.
So may I now ask Professor Laura Huici, who will be the one who introduces Professor Stefania Negri from Salerno, as I said before. Please come to the floor. Thank you.
Okay, hello everyone. Welcome to this new series of conference in the Aula Mediterrània. I thank you, the European Institute of the Mediterranean, for inviting the Master of International Studies in the University of Barcelona to inaugurate this series of conference in this year, 2022-2023, this academic year that we are now. I'm very happy to initiate this series of conferences because this year for our master program is also the Mediterranean is becoming a very important subject. We are not only collaborating with the IEMed in this series of conferences, but organizing a congress in the University of Barcelona with the cooperation of the Institute as well, about the sustainability in the Mediterranean. And so you are all invited to come on December the 19th in the framework of the celebration of the 750 years of the Consolat del Mar, which is originated in the city of Barcelona and also explains the importance of Barcelona and Catalonia in the Mediterranean region and in defining the law of the sea, rules of law. Well, I'm here to introduce you Stefania Negri, who is a professor of international law in the University of International Studies of Salerno. And she is an expert. Her career has been developed in the areas of health law, environmental law, human rights law, migration law, always from the international perspective. And she's currently an expert on environmental and health law. She holds a Jamonet Chair in European Health, Environmental and Food Safety Law from 2016 to 2019. And she is currently a member of the National Contact Point for Italy for the European Association of Health Law. And she was also a member of the interest group on international health law. She was a member of the steering committee of this group in the European Society of International Law, member of the Committee on Global Health Law in the International Law Association, and convener in the interested group on international European Union health law. So and she's really an expert on the issue that we are going to have the opportunity to listen to her today, and this relationship between environmental protection and also health in the region of the Mediterranean. In all these subjects, she has published several articles and directed different research projects. And I'm not going to mention all of them because it would be too long. I just want to end this introduction by thanking her for accepting our invitation, and I'm eager to hear what she's going to share with us today. Thank you.
Thank you. Thank you very much, Laura, for your kind presentation. Thank you to the European Institute of the Mediterranean for the invitation also, and to you especially. And thank you to Ambassador Florenza and Dr. Royo for their presentation and their introduction to this inaugural conference. It's a privilege and a pleasure to be here. I feel the burden of starting this conference cycle. I hope not to deceive you too much, so be patient. I was asked to deal with the crime of ecocide. This is a field, this is my second love, I would say. Environmental law. As Professor Huici said, I've been focusing on international and European health law since 2008, 2009. And since then, I have tried to develop also a new field, which is not so developed in academic research, which is environmental health. And so this is the reason which pushed me to apply for this Jamonet Chair. And at the end of the 3 years, we also produced a book on environmental health and legal responses in international EU law, and I had the privilege also to have two authoritative colleagues from the University of Barcelona, Professor Marc Campins and Xavier Fernandez Pons, as contributors to the book. Now, ecocide. Why ecocide? There's an exceptional movement, exceptionally strong movement at the moment, pushing towards the recognition of ecocide in international law, and especially in international criminal law. The work is done mainly by the Stop Ecocide Foundation. And it is this issue of recognizing this general category, environmental crime, has gained momentum. And this is the moment when they are trying to make governments adopt this kind of offense, criminalize ecocide in national criminal law. And they're also trying to have it included in the statute, in the Rome Statute of the International Criminal Court. So starting from the importance, a consideration of the importance that recognizing this general category of environmental crimes could have at both national, European, and international law. I would like to try to offer you or to provide an overview of the global legal framework, because environmental crimes, as you know very well, are a multifaceted and complex phenomenon. There's a lot of aspects to take consideration of, and the response from the law is not always up to the task. So I will try to go through this these topics or these aspects of the topic. First of all, I would like to introduce some basic data on the phenomenon of environmental crime and the fundamentals to grasp the essence and the complexity of the phenomenon. Then I will move to the definitions. There's no generally accepted definition under international law, but quite a few have been proposed at both international and European level, and major categories of environmental crimes have been recognized and grouped as such by the major international organizations that are acting in this field. Then I will try to offer you this overview of the global legal framework and international, relevant international and European sources, and then we will go back specifically to ecocide. Now, by way of introduction, what are the major points to take into consideration? First of all, the general concern about the damage that environmental crimes cause to the natural environment and to public health. So these problems go hand in hand, and this is one of the aspects of the general phenomenon which is mostly taken into consideration, because victims of environmental crimes are not only natural resources or ecosystems, but also us all. So present and future generations may be the victims of environmental crimes. And this also deals in a manner with the way that the problem is approached, either from a more ecocentric or a more anthropocentric point of view. Environmental crimes also have an important dimension related to organized crime. They are considered the fourth criminal activity which generates more revenues. It has a growing rate which is exceptional per year, around 5–7%. It only is preceded by drug trafficking, human trafficking, and counterfeiting. So you can imagine the volume of revenues and benefits that it brings to organized criminal activities. And also, these high revenues are coupled by a very low risk of detection and a very low risk of prosecution and sanctioning, which makes it extremely profitable and an advantage for organized crime as compared to other criminal activities. From a strictly legal point of view, the arguments that are put by international lawyers mainly concern the fact that environmental crimes affect global values and collective interests shared by the international community as such. Most provisions of international law protecting natural resources or ecosystems are considered as erga omnes, as creating or imposing on states the so-called erga omnes obligations. I'm sure you're familiar with this concept, so there's no need to go through it, but it is very important. governance obligations can be invoked by any state, no matter whether it is the victim of an environmental crime, no matter where it is, where it occurs, or by the hands of whom it is caused. So, criminalizing certain environmental harms is considered the best response. So, recourse to criminal law is considered the best response to environmental harms. And this is a solid concept shared by the United Nations, the European Union, all major international organizations. The United Nations, for example, considers that combating environmental crimes is part of a rule of law, the environmental rule of law. And the Council of European Union has put this fight against environmental crimes among its priorities, still renewed for the period 2022 to 2025. So in its policies, this is one of the major categories of crimes which has to be tackled, and responses are needed. So what about criminal law? Criminal law can offer a response at multi-level, with multi-level dimension. It can be used at national level, at European level, at international level. So it's something that can really make the difference if, and to the extent that the most serious and most dangerous conducts causing damage to the environment and harming public health are considered offenses, so are typified in national criminal law and are introduced as unlawful acts, as illegal acts under international law and European law. So if we have these international and European provisions, we have obligations that stem from on states, and this as a cascade creates a commitment for governments to tackle this phenomenon and to provide a solid, a robust response. Now, to have an idea of the complexity of the phenomenon, you should bear in mind that you have to take into consideration the whole spectrum of variables, of dimensions, of aspects that environmental crimes include and encompass. And I've tried to synthesize some of the major ones, starting from actors. Who can be the author of an environmental crime? Anyone, any actor, both state actors and non-state actors. So you range from governments to legal persons, corporations, individuals, and of course, in organized criminal groups. And also the variety of conducts that can have relevance as offenses and as environmental crimes. So a plurality of them, and not all of them are currently considered offenses under criminal law, neither at national level nor at international level. So this is a gap, this is a shortcoming that has to be remedied, that has to be put right through an integration and a development of national criminal law and international and European criminal law. Another aspect which may be a condition for also establishing which is the best penalty, the best sanction, the most effective sanction, is looking at the effects. And then here you have quite a broad range of effects on ecosystems and on human beings. So it can be just environmental harm, can be destruction of ecosystems, can be natural disasters caused by damage to the environment. It can be also long-term effects concerning loss of biodiversity, climate change, or just threat to individuals in terms of loss of lives, injuries, or an attempt, a hazard, a health hazard. Let's move to responsibility. Here again, you have to consider different systems and regimes of responsibility. And they very often proceed in parallel. So you have to cover all the situations and all the possible liability situations. So you have international responsibility of states, you have criminal responsibility of individuals at both national and international level. You have corporate responsibility, and this is probably the most controversial and most crucial aspect, because corporate responsibility at the moment is only provided under domestic law, which can make corporations responsible or liable for environmental harm under administrative law, civil law, criminal law. There's no corporate responsibility at the moment under international law. This is being negotiated at the United Nations, but not still work in progress. So we don't have a precise and a final regime that we can apply. Also at European level, we do have a European liability directive. This is not enough. European institutions are pushing for a revision also of this directive, in addition to the European Criminal Directive that I will mention later. So there's a gap still here to be filled. And then think about responses of the law and remedies. Here again, we do not have a specialized international court. There have been proposals for the institution, well, actually it was an Italian Postiglione who proposed this international environmental court, which has never seen the light, never been created, with a result that interstate disputes concerning offenses to the environment or environmental damage end up in different before different courts, be it the International Criminal Court, be it the International Tribunal for the Law of the Sea, or other sectorial courts. Here again, on the criminal individual responsibility side, we have a very limited competence at the moment of the International Criminal Court. As I will explain, it can also prosecute presumed or alleged environmental criminals if they have committed environmental crimes in times of war. So this dimension of environmental offense is at the moment codified only as a war crime. But most of environmental harms and environmental crimes do happen in times of peace. So this is still one big gap that the law at the moment still presents. And then we have another parallel way of having access to remedies, which is access to justice and redress, claimed or invoked by victims before human rights machineries or courts. Talking about health and the environment and climate change, I would like to remind you that there have been many cases brought to human rights courts and also the Strasbourg Court, alleging a violation of state obligations with regard to climate change related obligations through the argument that it causes harm to categories of persons like minors, like elders. So the right to health is used as an argument to have access to this court and to ask these courts to a certain responsibility of states for non-compliance with their obligations in the field of reduction of greenhouse gas emissions, for example, through the argument of their obligation to prevent and avoid health hazards to the population in general and to the person who are under their jurisdiction, more broadly considered. So, is there a definition why having ecocide clearly defined and accepted at international level is important? Because so far there's no generally accepted definition. So there's no unique definition of environmental crimes. and no recognition at customary level of this general category of environmental crimes that may encompass any act that causes widespread, long-term, and severe damage both to the natural environment and ecosystems and to individuals. So any legal act broadly conceived could be considered as an environmental crime. We have two hints which come from the International Law Commission of the United Nations and from the European Commission, but they are limited to the environment to the legal environment, I would say, where these definitions were produced. And the International Law Commission defined environmental crimes as a serious breach of an international obligation of essential importance for the safeguarding and preservation of the human environment. Here again, as we will see, this definition was provided in the framework of defining the international crimes in an attempt that the Commission made with a project of articles that it adopted in 1980, and it was referred to the importance of a certain category of obligations, of international obligations, these erga omnes obligations that I was mentioning before, but after that it lost its momentum and its importance. While the European Commission refers any definition of environmental crime directly, it links it to the European legislation in the field of environmental protection. So any violation of EU law concerning the environment is automatically an environmental crime. But this is, once again, restricted to the EU legal framework. Other international organizations have tried to provide definitions. The United Nations Programme for the Environment and Interpol, both committed to tackling and responding to environmental crimes, have agreed that these categories of crimes encompass illegal activities harming the environment and aimed at benefiting individuals or groups or companies from exploitation, damage, trade, or theft of natural resources, including serious crimes and transnational organized crime. I have to look at them, otherwise I will be too long. The same for Europol and the network against environmental crimes, always at European level. So they suggest that any legal action with a negative harming impact on the environment, this is very weak, I would say, as a definition, so maybe not even worth mentioning. What is interesting is that all these international organizations agree that, in general, you can single out 5 major categories of environmental crimes, grouped under the illegal trade in wildlife, illegal logging and trade in timber, the dumping and illegal transport of hazardous waste, illegal trade in ozone-depleting substances, and this specific category of crime, which is, once again, typified under EU law. So there's no international legal source, but there's a regulation from the European Union which is addressed to tackling illegal, unregulated, and unreported fishing. What kind of fields and sources we have to look at? What are our main reference points from a legal point of view? Quite a few. Quite a few at this different level of international and European law. You have at international level the law of state responsibility, and I will show you to which extent it is relevant, especially for a definition or an attempt to define international crime and environmental crime. We have treaty law at international level, so MEAs, which are multilateral environmental agreements, especially the few ones that criminalize environmental offenses are only 3. I will mention them in a minute. And we have general principles in international environmental law, which are also relevant because they are of general application, so they also are applicable in the field, of course, and especially in the field of environmental crimes. And then we have international criminal law, as I said, with the Rome Statute, the only provision which at the moment criminalizes environmental harm as a war crime, as I would say, and also a policy paper issued in 2016 issued by the Office of the Prosecutor, which prioritized the investigation and prosecution of cases implying in some way environmental crimes as the final product of the crime or as a means to commit other kinds of crime. If we move to the regional level, so European Union law, you have Articles 4 and 191 of the Treaty on the Functioning of the European Union, which depict broadly the policy, the environmental policy, and the objectives that this environmental policy of the European Union has to broadly, protection of the environment and of human health. The same is endorsed and repeated in Article 37 of the Charter of Fundamental Rights of the European Union. Then you have a panoply of directives and regulations addressing a wealth of sectors and a wealth of problems in need of response and protecting the environment. And then we have 2 major sources of law, 2 major legal instruments concerning European criminal law and specifically focused on environmental crimes. Council of Europe Convention, which I would say sadly failed. Its objective never entered into force. And the currently in force European Environmental Criminal Directive, which is being revised. There is a proposal adopted advanced in December 2021, which is being studied, and it will be adopted, hopefully in a while. I said the state's responsibility is especially relevant. I don't know, many of you are familiar enough with the categories of international law and with the law of state responsibility. But for us international lawyers, there is one legal instrument which is not a convention, but is similarly, I would say, a pillar, I would say, of the international law, and is the draft article on the responsibility of states for unlawful acts. Now, what it is interesting that in a previous version, not the current one which was adopted or approved in 2001, this previous version dating back from 1980 included this provision which has disappeared. This provision was interesting because it made a difference between international crimes and international unlawful acts or delict in general. And even more interesting were the examples that the International Law Commission offered to define or to give an idea of what could be an international crime as compared to any other kind of international unlawful act. And it qualified these international crimes especially for being a violation of an international obligation essential for the protection of fundamental interests of an international community. That violation qualified as an international crime. And the Commission wrote these examples. The violation of the prohibition to use armed force, so the prohibition of aggression or armed attack. A violation of another important and basic jus cogens norm that was the principle of self-determination of peoples, and another category of jus cogens norms, which are all the prohibition of gross violations of human rights. And it added another category. So it elevated the protection of the environment at the same level of a basic fundamental interest shared by the international community as such, and added as a fourth typical or maybe reliable example of environmental crime, a serious breach of an international obligation of essential importance for the safeguarding and preservation of the human environment, such as those prohibiting massive pollution of the atmosphere and the seas. In its commentary, it gave a number of more detailed examples of what could be considered massive pollution. But it was interesting that the preservation and the protection of the environment represented and was recognized by the international community at the time as an essential value, as a global value, as a shared collective interest, and that would have been extremely important had the Commission left this provision in the draft articles. But unfortunately, it deleted it. And in the version adopted in 2001, the distinction between delicts and crimes just disappeared. And what was replaced by it was this provision, which referred to essential obligation, to global values, to breached owed to the international community as a whole, or to the concept of protection of collective interest, only to the extent that this breach legitimized third states, third countries, third governments, not directly affected by this breach, to invoke the responsibility of the offender. So this was the dimension that came to relevance, and we lost that very interesting reference to the environmental crimes that could have been codified at the time. So among the examples, we still have some reference to environmental damage, but it's really, really little. Let's move to general principles. We have here a wealth of general principles of international law that apply to the field of environmental law. It can be used usefully to tackle environmental crimes. I will not read them all because I think that would be too long, but I'm sure that many are very well known to you. I would just mention protection and precaution. I think they are the best known. The precautionary principle is one of the most controversial, but most important in international legal framework. The polluter pays is another very well-known principle applied, which is the basis of EU law in terms of remedies to environmental crimes. Intergenerational responsibility, as I said, is relevant to the extent that we know that some environmental crimes do have consequences, long-lasting consequences, and the effects will be suffered by future generations as present ones, and also common but differentiated responsibilities, which is very common in the climate change sector. So states have to remedy or to act in a proportional way as they are the authors or the producer of environmental harm. And then, of course, the prohibition of transboundary environmental damage, which is a very robust norm in international law. Now, if we move to treaty law, we only have 3 multilateral environmental conventions criminalizing environmental offenses. And this is very, very little. If you think about the number of multilateral, bilateral, regional treaties addressing environmental problems and trying to provide the most effective protection through legal measures. So only 3 and some of them are also really dated, but still particularly important. The CITES Convention. CITES Convention protects endangered species of wild flora and fauna from extinction. The Marpol Convention, which concerns pollution from ships, and the well-known Basel Convention on the control of transboundary movements of hazardous waste and disposal. I may not maybe go through in details, but I will pass over the slides more quickly. But what is important that having this obligation to criminalize this kind of offenses creates a commitment, creates a legal obligation, a binding obligation on states to include within their criminal law this kind of offenses, thus to typify these environmental harms or these conducts that cause damage to the environment. So it's somewhat of an indirect criminal law source, coming from international law and being transposed into national law when every state party ratifies this convention and transposes it into domestic law. The European Union is not a party to all of them, as it is indicated in this slide, but nonetheless, even where it is not a party, and I'm referring to the Marpol Convention in specific, it does contribute to its implementation through some dedicated directives that you can see here, and so it has its own role in preventing pollution from ships, and so protecting the marine environment. As far as the legal trade in wildlife is concerned, we are talking about those species that are threatened with extinction. So not all wildlife trade is illegal. It has to reach a threshold of overexploitation, which puts in danger the survival of these species and also, as a consequence, biodiversity and the variety of ecosystems. CITES is an almost universally accepted convention. It has, at the moment, 184 state parties. It protects more than 44,000 species. And these species are protected through criminal law. States are bound to penalize trade, possession, and exploitation of these specimens within criminal law, and they have to adopt measures, remedial measures, concerning the confiscation or return to the state of export of these specimens. And these different resources and species are, let's say, divided into three categories, corresponding to the appendices to the CITES Convention, depending on the circumstance that they are threatened with extinction. They are not necessarily threatened with extinction, but must be put under specific control, or they suffer specific hazards in regions or individual countries, selected countries, and these countries can ask to have an international monitoring or control of trade of these species. Then there is this secretariat, which works in coordination and in collaboration with other international organizations. Maybe I will leave the slides, so maybe they can go through them. Marine pollution. So marine pollution, you do find some general provision already in the United Nations Convention on the Law of the Sea, and I could add the Barcelona Convention, of course, on the protection of the Mediterranean Sea, but this gives the general framework. Once again, no specific obligation to criminalize conducts that create pollution of the sea. hazards to the marine environment or long-term, widespread and severe damage to the environment. But we do have this in the Marple Convention. So the Marple Convention, here again, not universal participation, but nonetheless 158 state parties at the moment. It offers definitions of what can be considered as a discharge of polluting substances within the sea, and it applies, of course, to all commercial ships flying the flag of one of the state parties, and also, an interesting thing, it provides for a double system of criminalization and sanctioning, both from the state of the flag state and from the state where the environmental crime has occurred. So two jurisdictions have the power and are legitimized to react to environmental crimes. It does not apply to warships or to other governmental ships which do not practice commercial activities. And as I mentioned, the EU has a role with this directive of 2000, from 2000, and the other one amended in 2009. Another important convention concerns prevention and control of movement, of transboundary movement of hazards related to hazardous waste. This is the Basel Convention. The Basel Convention also makes an effort to have states criminalize transboundary movement, illegal transboundary movement of wastes, although it does not impose an obligation to criminalize these conducts, but requires states to consider as criminal all this illegal traffic in hazardous wastes. So this is a weaker solution, trying to prompt state to make recourse to criminal law, but nonetheless, it is not the object of a precise and clear binding obligation stemming from the convention. Okay, this maybe we could skip. Yeah, otherwise we don't have enough time. I would like to move straight to international criminal law. We still have a lot to go for European law, so I will be quicker than what I expected to do. Here again, the International Law Commission, a codifying body of the United Nations, subsidiary organ of the General Assembly. I didn't mention this before, but anyone, I think, is familiar with this codifying body. Also worked on international criminal responsibility and produced in the 90s a couple of draft codes of crimes against peace and security of mankind. It did not reach the final result because in the meantime they negotiated the Rome Statute of the International Criminal Court, so the Commission thought that that was enough. It would become the codification of international criminal law, so stopped its codifying work and deferred, let's say, to the work of this of the conference which negotiated the Rome Statute. Nonetheless, in the version adopted in 1991, the draft code included a very interesting provision criminalizing willful and severe damage to the environment. And it was phrased in these broad terms, but it was important because it could be applied in both peacetime and wartime. And this was important because in peacetime, it was one of the first provisions offering the possibility of criminalizing any environmental act, environmental crime, having these effects, being committed with intent and being considered for its extent and the intensity of damage, the persistence in time of the effects, and the geographical extension of the damage. So something that had to be widespread, long-term, and severe. Here again, a step forward, a step backward, pardon, a step backward. And despite the broad explanation that the Commission gave to make the interpretation and application of that provision as broad and as effective as possible, imagining all these kind of elements of the natural environment that could be protected through that criminalization. Here again, in the subsequent version, the Commission deleted Article 26, so it renounced to having a specific environmental crime which could be prosecuted if it occurred also in times of peace, so at any time. It limited its attention to war crimes. So included in war crimes the case of crimes occurring during an unarmed conflict, using methods or means of warfare not justified by military necessity, and with the intent to cause widespread, long-term, and severe damage to the natural environment, and thereby causing gravely prejudice to health or the survival of the population. This reduced the scope, of course, and also reduced the competence of a possible future international criminal court only to the strict category or limited category of war crimes. And the Rome Statute, unfortunately, endorsed this approach and included in the Statute of the International Criminal Court the same, more or less, provision limiting criminalization and prosecution of environmental crimes only if committed in wartime, so as a war crime, which again leaves a gap in international criminal law and in some way weakens its effectiveness and is a major shortcoming. And to remedy this shortcoming, the Office of the Prosecutor of the Court in 2016 issued this policy paper. They are papers which are issued very often by the Office of the Prosecutor to explain its trajectory, its priorities. And in this case, it was interesting in as much as the intention of the Office of the Prosecutor was to prioritize the analysis, investigations, and prosecution of cases which were committed by means of or resulted in the destruction of the environment, the illegal exploitation of natural resources, or the illegal dispossession of land. So the International Criminal Court, as they said, was greening its policy, focusing specifically on crimes that had an environmental dimension, crimes that were affecting the environment, which had the environment at the target, or damage the environment to cause other cause other kinds of damage or to commit other kinds of crimes. The aim was to select these cases in light of the gravity of the crimes, the degree of responsibility, and the potential charges. And in this case, all the criteria to implement this policy were provided. Ecocide was an attempt made at international level ever since the mid-70s. In the mid-70s, Richard Falk, which is an exceptionally famous American international lawyer, worked on a possible draft convention on ecocide. It drafted this convention, which never saw the light, unfortunately, was never approved by the United Nations, was never adopted as a draft convention to be open to the ratification of states. So it remains as the testimony of a nice academic endeavor, which had its relevance, but unfortunately had no sequence. But there was this UK lawyer, Polly Higgins, who passed away some years ago, who fiercely advocated the recognition of the crime of ecocide at international level, and also framed this definition, proposing it to the International Law Commission with an aim to having it included either in the draft articles on crimes. Okay, well, I was sure it would be long. In the draft statute or in the draft articles on crimes against humanity or in the Rome Statute. Polly Higgins also founded a foundation with Giorgio Meta, which is Stop Ecocide Foundation. I think you may have heard about this. This is extremely active at the moment. It is the most active foundation at international level, advocating for the recognition of ecocide, both in national law and at international level. The foundation convened a panel of independent experts. The very famous Philip Sands from the UK was one of the co-chairs, and they proposed this definition of ecocide to be used for the sake of including a new Article 8 ter in the Rome Statute of the International Criminal Court. So they defined ecocide as the unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. It is interesting that intent is no longer, the dolus specialis is no longer an element of the crime. So it is a bit milder, knowledge that there is the substantial likelihood, and the requirements are not accumulative, either widespread or long-term damage. And the environment, of course, covers all dimensions of the natural environment as defined by the same proposal of this provision, which in the intention of the foundation should be examined for a future amendment of the Rome Statute. So this is the idea of including the crime of ecocide to remedy the lack at the moment of a provision criminalizing environmental crimes or a general category, a broad category of environmental crimes committed during peacetime. There's no link to war or whatever condition of armed conflict, so this would complement, support, and integrate the current state of the law and would be an enormous step forward in trying to bring to justice environmental criminals, be they individuals, be they also directors of corporations, which would be also some kind of remedy to the lack of corporate liability at international level, as I said before. I will skip very rapidly, but just to let you know that at the regional level, we had this attempt made by the Council of Europe, which drafted this convention. It was aimed at harmonizing in the broad Europe, not in the EU limited number of member states, criminal law concerning the environment. Unfortunately, it did not even reach the minimum of 3 ratifications for its entry into force. Some signed it, only Estonia ratified it, but it was a big failure, and I think it's one of the few cases where a Council of Europe convention does not reach its purpose or its stated aim. And of course, it included the major categories of environmental crimes that we have already mentioned, so I will not read them all. fishery crimes mainly refer to this specific regulation of 2008. And here again, there are specific sanctions. There is also the possibility of sanctioning illegal and unregulated fishing activities wherever they occur, to the extent that they are committed by ships flying the flag of one of the EU member states, wherever in the world. They can also have other kind of sanctions, like blacklisting, for example, of states that do not take action against this environmental crime. At the moment, in EU law, we have this directive, 2008, number 99, on the protection of the environment through criminal law, better known as the Environmental Crime Directive. It refers to criminal offenses that are committed intentionally, or at least with negligence. And it refers to environmental crimes as any violation of all and any EU piece of legislation on environmental law, on the protection of the environment. Nonetheless, Article 2, let's say, refers to these annexes which list all EU legislation, relevant legislation, and Article 3 includes a list of specific offenses and environmental categories of environmental crimes. The Commission evaluated the effectiveness, made an evaluation of the effectiveness of the directive. And results were not so, I would say, positive. This prompted the Commission to propose a revision of the directive, and it drafted a text that was submitted to the Parliament and the Council as the co-legislators in order to put remedy to the shortcomings that were revealed by its application over time. First of all, that it's no longer in line with the current state of EU environmental law. So many other directives and regulations have been enacted, and the directive does not cover violation of these legislation. It is not aligned anymore with current environmental challenges, for example, illegal timber trade or ship recycling. And also, one of the major problems when transposing directives is that national legislation offers a broad variety of solutions, and especially in the field of criminal sanctions, not all governments, not all legislators act the same way and make the same choices. So what the European Union asks that sanctions be effective, proportionate, deterrent, and so on, is not always put in practice and implemented at the same level of efficacy and effectiveness in the various legal orders. So what the Commission would like to do is to harmonize also sanctions. So in a part or in addition to introducing new offenses, in aligning the directive to the current state of EU law on environmental protection, it also wants to strengthen provisions on criminal sanctions and to indicate what specific criminal sanctions have to be applied, the level of gravity, so that the environmental crime is not sanctioned with a very mild sanction in one government and with a very heavy criminal sanction in the other. So harmonization should be better, should be improved with this kind of new solution. And also another objective is to increase investigation and prosecutor through cross-border cooperation. So it also it is based not only on Article 83 on harmonization of issues having a criminal relevance for criminal law, but also has something to do with the area of freedom, security and justice, so with cooperation in the police and justice field. Let me see. Yeah. So this is the list of crimes that should be included as new entries, let's say, in the new text of the revised Environmental Criminal Directive. And the EU, but the EU has not provided for the inclusion of this general category of ecocide, but it still supports recognition at the international level. Both the European Parliament and the Commission are pushing towards supporting this recognition. They also have committed European institutions to make, and committees to make a study to ascertain the relevance of ecocide for EU diplomacy and legislation in general, EU law, but nonetheless no ecocide is going to be included as such in the revised Environmental Criminal Directive. So by way of conclusion, and I won't make it too long, we do have some reference point. First of all, which all call for and are a good argument to advocate recognition of ecocide, especially in a region like the Mediterranean region, where there is a special interest to protect natural ecosystems and the marine environment, first of all. So, faced with the problem that there's no generally agreed definition, there's no general regime of state responsibility, no general regime of international individual criminal responsibilities, and harmonization of criminalization has still to be reached and improved both at EU level, let alone at international level, where we have even less and less number of relevant provisions. So recognition of ecocide could somehow represent a step forward. This would be, let's say, to be heralded and to be fostered within national criminal law, first of all, but also possibly at EU level. And if the Statute of International Criminal Court is revised with this amendment, including the proposed Article 8 ter, as suggested by the Stop Ecocide Foundation, we would at least have a more complete and more effective global legal framework, which is apt to remedying and bringing to justice the authors of environmental crimes. And thank you for the attention, and sorry if I've been too long.
Thank you very much for a very interesting and a very broad presentation of all the... Well, there's a lot of things to be taken into account. Maybe we have maybe some time for discussion, for questions. If there are questions, someone that wants to participate now, you have the floor. Anyone? I would like to, because
I talk too much.
Yes,
please, for questions.
Or maybe. Well,
I understand. Don't worry.
I just take the first, and in any case, because I was thinking, you didn't mention how much of this, because there is this process of recognition of the human right to the environment.
Yeah.
How much that influences or might influence this process of criminalization.
It is no doubt supporting this. It is extremely important, the step that has recently been made with this statement from the General Assembly recognizing the right to a healthy environment opens new spaces for human rights related to environmental dimensions. And this, of course, they are mutually supporting, I think. They have advocated for official recognition of this right. As you know, very few legal instruments include it. Most has been done through the jurisprudence, through the case law of international courts, and especially the Strasbourg Court, but also the African Commission has done a lot on this side. I think that they are mutually supporting arguments. So the human rights dimension and the punishment and prosecution, so rights and obligations would go, would proceed in a parallel way, but they are mutually supporting. So the momentum that we are, the right to a healthy environment has gained lately, I think it's strengthening also general advocacy for the recognition of ecocide, because that would be an issue related to the violation of this fundamental right, I think.
So thank you very much for all your explanation. In fact, you are talking us about a new branch of criminal law that's in the making, as we have seen. So what would be your guess at when will we have really enforceable norms for courts, I don't know which ones, at the international level, because there is, of course, nowadays a very strong social demand for that.
Yeah.
So winds are blowing in a favorable way for that. So shall we still have to wait 20 more years or 2 years? Or?
The Conference of the Parties to the Rome Statute is going to examine this proposal, not too far away. And it is hoped that such a strong international movement supporting this proposal will have its influence on the decision of the Conference of the Party. So there might be some good chance that they include this, this new crime, or at least this could be I would say, I missed the word, but it will prompt at least governments individually to complete their criminal legislation, and if we have that provision, at least in domestic criminal law, it's already one step forward, because if we recognize it as an international crime or as a crime under international law, then I think we could apply the principle of universality of criminal jurisdiction, for example. So that would empower or legitimize any state to prosecute an environmental criminal. Independently of any specific competence of the International Criminal Court. If the two things go hand in, that would be perfect. But dreams are.
Any other questions? No? Well, I think we are in the time, so I will close, but just to, I want to really stress the importance of the subject that we have addressed today, and the urgency in this recognition. Today there was in the news, there was information about a report that has just been published talking about the disappearance of half of the main glaciers, I don't know, glaciers, we said that in English, glaciers in the world, one in the Pyrenees, the Mont Perdut, for example, that are going to disappear before the 2050. And if we are not doing something, we will have more glaciers disappearing in the following years. So it is obvious that the protection of the environment it is a necessity, and it is an urgent issue to be addressed right now, and criminalizing the crimes, not the illegal actions against the environment, it is certainly a way to move forward, and probably a necessity, together with this recognition of the environment as a human right, or maybe, as it was mentioned, also a nature, not only an anthropocentric point of view, but also from the Earth point of view as well, which is also a discussion that is being held now. So thank you very much, everyone, to come and to share this time with us, and thank you to the IEMed to give us this opportunity. Thank you.
Thank you again. Thank you.
Muchas gracias. A ti. A ti. A ti.